It's one thing to know what the statutes say the law is when it comes to self-defense, but it's very important in a common law system such as ours to understand how judges have applied that and how the common law has added further understanding to that law. That's why this week on Don't Talk TV, we're going to cover some of those cases that have dealt with our self-defense law. Hello, my name is Nicholas Wansbutter. I'm a criminal defense lawyer in Stratford, Ontario, and this is Don't Talk TV. Last episode, I went through Section 34 of the Criminal Code of Canada and discussed what's laid out in those parts of the Criminal Code and what your rights of self-defense are statutorily. Today, I'm going to go look at some high-profile cases and some other lesser-known cases specific to Ontario of how that law is applied in practice. So first here, we have Edward Maurice of Okotoks, Alberta. In February of 2018, he was home alone with his daughter in their rural property just outside of Calgary when he was alerted by a dog's barking. He saw two people rifling through his vehicle and got out his .22 rifle and fired 2 warning shots. One of the warning shots hit the intruders in the arm with a ricochet. He called police, who attended 2 hours later with guns drawn, who arrested him for aggravated assault. Now, this is a high-profile case. It doesn't help us particularly in understanding how the law is applied, though, because his charges were ultimately dropped in June of 2018 as a result of overwhelming pressure from the public. A case a bit closer to home is the case of Peter Kill. You can find this case reported at Her Majesty the Queen and Kill 2020 ONCA 151, and that's available on Canley. Mr. Kill was charged with second-degree murder. So Mr. Kill was acquitted by a jury at trial. The Crown Attorney then appealed that acquittal to the Ontario Court of Appeal. And so that judgment is very helpful in understanding the current application of Section 34. Now, by way of background, paragraph 6 of that decision gives a good overview. It says that Mr. Kill and his then girlfriend and now wife, Millie Benko, lived in a single-story house in a rural area near Hamilton, Ontario. Mr. Kill was asleep at about 3 a.m. on February the 4th, 2016, when Ms. Benko woke him up and told him she'd heard loud banging. He saw a person in his truck. He then sneaks through the house, sneaks up on the individual ransacking his truck, and confronts him with a shotgun. Mr. Kill said in a loud voice, "Hey, hands up." And Mr. Stiers, who apparently had not seen Mr. Kill, began to rise and turn toward Mr. Kill. As he turned, Mr. Kill fired a shot. He immediately racked the shotgun and fired a second shot. Mr. Kill said that he thought the deceased had a gun and was reaching for it. Now, part of Mr. Kill's defense was that he was an Army reservist from 2007 to 2011, and he said that therein he'd been trained to deal with situations proactively, and he had turned on a switch and gone into a military mindset when he heard this individual going through his vehicle. The Crown Attorney argued on appeal that Mr. Kill's military background should not have been relied upon by the jury and should not have been taken into account when assessing reasonableness. Now, the Ontario Court of Appeal allowed that evidence to be taken into consideration. Personally, it would be interesting to see what exactly the expert called had to say about that. There's pieces of it in the Ontario Court of Appeal. Frankly, I find it a little bit dubious. As someone who served in the Canadian Army, I was also a reservist. I was an infantry officer for about the same amount of time that Mr. Kill was in the reserves. I served from 1999 to 2002. I certainly don't know about this flipping a switch and turning into having a military mindset, and that this would lead me to think it's reasonable to sneak up on someone, surprise them, and then shoot them twice with a shotgun. Frankly, I would have thought that that would have gone against him, that having military training, he would have been even more careful or cautious in knowing what could have been done, and he wouldn't have been as panicked as the average Canadian citizen might have been. That said, the Ontario Court of Appeal overturned the jury acquittal and ordered a new trial because they said that nowhere in his instructions did the trial judge tell the jury to consider Mr. Kill's role in the incident in assessing the reasonableness of the shooting of Mr. Stiers. So in other words, the trial judge didn't tell the jury to consider the actions taken by Mr. Kill and how those may have contributed to the situation and led to the shooting. For example, the fact that he snuck up on this individual and surprised him and confronted him versus just staying inside his home in calling the police. Now, that doesn't mean that an individual is always required to call the police, or that an individual is required to cower in fear, but it is something to be considered in the circumstances that he confronted this individual versus that individual confronting him. For example, I think it would be a much different situation if you're in your home and someone kicks in the door and attacks you. What would be reasonable steps there versus going out and seeking out that confrontation? So the Court of Appeal overturned the acquittal and ordered a new trial. Now, that has since been appealed to the Supreme Court of Canada, but as far as I know, that appeal has not yet been heard. So some other cases in Ontario, there's the case of Her Majesty the Queen in Parker, and that was a case of an accused charged with assault caused bodily harm. He and the complainant in that case had spent the evening drinking together, and upon returning to the complainant's apartment, the complainant suddenly, for some reason, attacked Mr. Parker and jumped on him and grabbed him in some sort of wrestling maneuver. Mr. Parker gained the upper hand and punched the complainant in the head a number of times. Now, importantly, there was surveillance video of this incident, and it showed that once the complainant had stopped moving and was unable to return force, Mr. Parker for 18 seconds continued to punch him. So in that case, Mr. Parker was convicted. And I think it's clear that he was convicted because after he had incapacitated his attacker, he continued hitting him for 18 seconds. If he'd stopped as soon as that individual was out, I think a different result would have been most likely. Another case is Her Majesty the Queen in Mudenji. It's a 2014 Ontario Court of Justice decision. In that case, the accused stabbed the complainant in the neck with a broken beer bottle, and he said that it was in self-defense, but it was in defense from being pushed. He was convicted because stabbing someone in the neck with a beer bottle is disproportionate use of force when all that's happened is that you've been pushed. Another 2014 Ontario Court decision is Her Majesty the Queen in Saunders. The accused in that case was at a Carabina parade in Toronto. He heard what he thought were gunshots, which caused him and others to run in panic. He saw that his friend was struggling with an individual over a shiny object. He thought it was a gun. So he then jumped in to try to disarm this individual, and during the scuffle, he hit this person. He was charged with robbery. It turned out it was a camera, not a firearm, that was taken from this individual. And in that case, he was acquitted, and the judge said that it was reasonable for him to believe that this individual had a firearm, given that he thought he'd heard gunshots, and it was reasonable to punch this individual for the purpose of disarming him from what he thought was a handgun. Another case, Her Majesty the Queen in Lincoln from 2015. A father and his son were asked to leave a function because of some of their behavior there. One of them retrieved a golf club and returned to the scene and then assaulted an individual there with that golf club. The court found that when he picked up the golf club, he was not facing any aggression at that time. He'd merely been asked to leave, and then he inserted himself back into the situation. He was not being threatened at the time that he swung the club, and was therefore convicted. The final case I mentioned is Her Majesty the Queen in Comer. It's another 2015 Ontario Court of Justice decision. In that case, the complainant's violent reputation, the fact that he had threatened the accused person the day before, and that he had threatened him again on the day of the offense, led the accused to reasonably believe that he was in danger. He preemptively punched the complainant, who fell and struck his head and was seriously injured. There was no evidence that there was desire for revenge. It was simply because he was scared that this individual was going to make good on his threats, and Mr. Comer was acquitted. So I think these cases give a bit of a flavor for how Section 34 is applied in the courts. In my view, it appears to be fairly generously applied. Where the cases where you see individuals being convicted, it's where there's just clearly no self-defense, where they're acting out of revenge, or they're just angry out of the situation, or they're under no real threat, acting totally disproportionately to what's coming at them. Whereas you can see a number of acquittals in cases where some might even say it's borderline that person was acquitted, but they have that reasonable doubt. You have to be proved guilty beyond a reasonable doubt. The Crown has to prove beyond a reasonable doubt that you are not acting in self-defense, and therefore an acquittal results. Today's episode will give some further understanding of how self-defense law in Canada works. Again, this video is not legal advice. If you're ever in a situation, call another lawyer or call myself. My 1-855 number is below, and we'll be happy to give some advice that's tailored to the specifics of your situation. I hope you found this video informative and educational, and if you enjoyed it, please consider hitting the like and subscribe buttons.